keep forgetting that second part is there, and I almost talk every single time.
It is what it is, man. I feel you.
Yeah, I'm Matt Mulholland. This is Alex Hefner.
Yep.
With an F.
Alex Hefner with an F.
Alex is with Daly Black, an attorney firm that has their own podcast. What's the podcast called?
The Brainstorm.
The Brainstorm.
Nice little play on storm. Thinking about some stuff with some like-minded individuals. So we just started unveiling that, and it's been a fun process, man. Getting to chop it up with a lot of different folks in the industry has been really cool.
I've watched a few of them, and the ones that I did watch, I was really impressed with, just because you actually get into some details on things. There's
Absolutely.
a lot of podcasts in this industry. The vast majority of podcasts in this industry don't do.
I found your podcast and made Matt watch them, to be fair.
Is that right? Wow, I'll take that. Right. Appreciate that.
I was wearing the hat one day and he said, "You should watch this."
Well, I appreciate it.
Welcome to the show. This is the Listen to This Bull live show. This is the show where you can ask us questions live and we have to answer. You can ask us weird questions. It's cool. You know, what kind of mustache wax do you use?
What kind of mustache wax do you use?
Lately, I actually don't know. The stuff that I normally use is not in stock.
Okay, fair enough.
And it's bothering me because the stuff that I have now is too weak.
Okay.
But most mustache wax are waxi.
Let's go with that. I like that.
Waxi. Most mustache waxi are too hard.
Okay.
And they have this real sharp point, which happens in the morning no matter what with me, but eventually it wears out. And the medium holds, the ones that I used to have, are so much better.
Yeah.
And the name of the brand that I like is Can You Handlebar primary wax.
Okay.
And they have a secondary that's really hard. I can't put the hard stuff on.
Dang.
This sounds like a bunch of innuendos.
It really does.
Yeah.
But the thing is, you can grow a very luscious beard and mustache. I'm sitting over here, Patch Adams, can't do anything. So there's no wax necessary in my future.
You'd be surprised. I actually have a few patches in my beard.
Do you?
It's like a Donald Trump comb over.
Okay. Not as patchy as me. I think I got you beat there, but
maybe
I'll take your word for it.
Maybe not that bad. Today we're talking about bad faith.
The infamous bad faith.
It is infamous.
Yes.
Because it's
tough.
It's hard to figure out sometimes.
It is.
So maybe we should establish some ground rules here.
Okay.
And for the audience, you can call in. Well, no, you can't call. You can write a comment. Where is that banner at? There it is. You can write a comment and ask us questions live. We want your questions. This show is a lot better if we have questions to answer. So
absolutely,
this is a huge topic. We're going to talk about bad faith, and that's different for a lot of different states.
Right.
So we're going to talk about it in a very generalized term. We are going to establish, some ground rules for what a contractor could do. Hopefully, we should get into, what a public adjuster should or shouldn't say. Maybe even some good examples of situations that are ambiguous and whether or not they're bad faith.
Right.
Have some fun with it. If you guys have a claim that has some issues and you want to know if you're looking at a bad faith claim, maybe we can even talk about how to set up a file for an attorney.
That'd be perfect.
That has some bad faith.
That'd be great.
I think we have too much to talk about already.
Oh, man, that's what I'm saying. Bad faith. Whenever you get into that topic, we could talk about it for days, and it still wouldn't be enough time to cover it all.
We could talk about it for days. There's a lot of defense attorneys here that might have a really good discussion with us.
Probably so.
Sounds like we might need a part two.
Definitely will. And actually, at one of the last conferences that we went to, one of our shareholders at Daly Black, James Willis, he did an awesome presentation on bad faith and kind of more along the historical perspective of it. So how it came about, how it came to be, what you can do, how to set up a file, right? Also covered different rules of evidence, different rules of hearsay, so that you can kind of really understand what can come in and what has to be left out of a courtroom based on hearsay rules. And it's been pretty awesome. So hopefully a part two, we could go a little bit more in depth with James. I think that'd be really, really fun.
That would be fun. I'm in Texas a lot too. We could probably even do it in person.
Yeah,
I'm really
absolutely
tired of doing the Zoom calls.
Over Zoom?
Oh my God.
It's a little bit more impersonal. I like this.
A little bit.
Face-to-face is nice.
I can hit you and
I know.
stuff. It's great.
Right? It's good. It's good.
Come on, man. It's
back and forth.
Right? All right, so Give me a rough definition. What is bad faith?
Okay. Well, I think it's important to note that, like you said, bad faith differs from state to state, right? So Daly and Black, our main office is based out of Houston, Texas. So the Texas definition for bad faith, and I actually wrote this down because a lot of times whenever you're dealing with the minutia in bad faith, it's very important to get the words down.
Did you write this today?
I wrote this today for this.
I would have been more impressed if you said that you brought it with you just in case you got onto the podcast.
I wanted to give my all and just really, really get into the minutia of it.
There's a lot here. You spent some time on that.
That's what I'm saying. So let's talk about the definition of bad faith in Texas. So in Texas, the definition is there is no reasonable basis for denial of a claim or delay in payment or a failure on the part of the insurer to determine whether there is any reasonable basis for the denial or delay. What does that mean in real person terms? What does that mean in layman's terms? It means that if there is no reasonable basis for a denial, a delay, or an underpayment, and that's broad, skimming the surface type of thing, but essentially that's what it is. And I know that you're in Georgia, so I took the liberty of defining it from a Georgia perspective as well.
Is there a definition?
And in Georgia, well, they not as strict as in Texas, and strict may be the wrong word to use, but in Georgia, they categorize bad faith as frivolous and unfounded refusal to pay a claim.
I remember the word frivolous. I use that pretty often in my emails as a result.
Well, I mean, as a lawyer, we hear that all the time. Frivolous lawsuits. What are you guys doing?
Right.
So, but I think it's important also to note, like, let's break it down a little bit. So with bad faith, there are two different facets, right? You got tort and you got contract. An insurance policy is kind of weird to think about it like this, but it is a contract. The policyholder's duty under the policy is to pay their premiums, right? And the insurer, the carrier, their duty is to make sure that payment is paid properly in a reasonable fashion, and inspection is done properly in a reasonable fashion, and that more or less, that's the quid pro quo for it. That's the bartered for exchange. That's the contract, okay? So in Texas, and whenever you're in trial, right, you have a jury. And with that, you're gonna give the jury some jury instructions. So let's take it on face value. The contract, the four corners of the contract, what the jury's gonna get in their first jury instruction is gonna be, did the insurance company fail to comply with the insurance policy agreement? That's the question that they answer. Breach of contract, exactly. What follows up, the next jury instruction is going to be based on a monetary value. It's going to say what sum of money would fairly and reasonably compensate the insured if the carrier, based on their actions, it led to their failure to comply with the contract. That's also it. So step one, was there a breach of the contract? Step two in the jury instructions is what is that monetary value? Step three, you start to get into more along the lines of the tort, right? So right here, I took this verbatim from a jury instruction that we've used in the past. Did the insurance company engage in any unfair or deceptive trade practices? Okay. And then you start to get to the real bad faith issue with the tort of it in terms of, did the insurance company knowingly act? Now, I get a lot of calls from different public adjusters and different CEOs of roofing companies saying, hey, man, I got a kick-ass bad faith case for you. Are we going to get treble damages on this? And, well, there may be a bad faith case, but the threshold to get treble damages is much stricter. It's harder to get. The insurance company not only has to act in bad faith, but has to do so knowingly and intentionally.
So the act of bad faith isn't in itself intentional.
Is bad? Well, it can be.
So bad faith can exist without it being intentional.
That's correct.
The carrier may act in bad faith unknowingly.
Exactly.
Do you find that you have to prove that? Is the burden on the plaintiff attorney to prove that they knowingly did something or that it was frivolous?
Well, that's a good question. So that you start to get into the ping pong of it. And this is James Willis's wheelhouse. This is what he's an expert in. And essentially what it is it's burden shifting, right? So essentially it's what the policyholder has to do is they have to prove that there was a covered peril. You have to prove that, yes, there was a peril according to the policy, and yes, it is covered because it's within the policy limits. Burden then shifts to the insurance company.
I'm not so sure that maybe there's some case law in different states, but for most policies, the insured is required to notify the insurance company of the damages, and they have to prove their damages, not necessarily that, well, they have to prove it was, never mind.
Okay, so
I can hit him. I really ought to be hitting myself right now, though. I mean, that's the beauty of these live shows, man.
That's the beauty of the live shows.
I feel retarded.
But I want to take a step back and really let's thank California. Now, this is just touching on the history of it, right? So what California did in the 1950s is they started to recognize a separate tort action. That's what we owe all of our good praises to California, especially in Texas, because we follow that California law, where an insurance company cannot deny claims when they know better, and two, they conduct an unreasonable investigation. So that's one of the most concrete examples.
Let me ask you a real
Sure.
quick question
Absolutely.
on that then. So the insurance company their obligation is to prove a exclusion or limitation in the policy if the insured proves the loss.
Yes.
A reasonable investigation wouldn't necessarily include investigating things that the insured didn't claim. Would you agree?
I'd agree.
So if an insured doesn't fully present their loss by not expertising themselves, is the insurance company required to uncover damages that the insured knew about?
I have a quote from a case. So this is...
How many pages you got? You wrote all this today?
I wrote all this today, man. This is a big
I
deal.
feel like if you had a printer, you'd have
I'm on your show. I wanted to come prepared. You know, I'm not coming half-assed with this.
I actually have a printer with me.
Do you?
Yeah, I can save you some time.
So what I found, this is a State Farm versus Vega case. Now, this is a case on reasonable investigations, right? Now, what the court case said is, quote, the jury heard evidence that Sylvia only inspected certain areas of the house and that Sylvia didn't inspect the attic. The jury could have reasonably found that it was State Farm's duty to properly inspect the Vega's house for damage and not Myra's duty as a layperson to know where the leak originated. That being said, if it was reasonable for the carrier to, so say you have roof damage,
What state
right?
was that?
This is a Texas case.
Texas.
So, and I'm not as well versed in Georgia law or other areas of the law. That's why I had to do some research. But so what that says is, hey, if there's roof damage and there's a leak, it's reasonable that one would check in the attic, right?
Right.
If they didn't make that reasonable investigation into the attic, some court cases that I found, they didn't make an investigation on the interior at all. And that was found to be bad faith. It's not necessarily the fact that the layperson has to know, like, this is where the damage originated from. This is where the leak is from. It'd be the same. Parallel it to a medical issue, right? If I go into a doctor and there's a case like that and I have a heart condition, it would be like the doctor saying, okay, well, what's your basic cardiac level? What are you sitting here normally doing? How does your heart normally operate? What are your aorta and all this valves? Like, they're asking you to be the expert, and you don't have to be the expert. So you don't necessarily have to know where the leak originated or anything like that, because it's on the insurance company to conduct a reasonable investigation to do so. And if they fail to do so,
Is there a point where it is reasonable for them not to have gone into the interior? If they never claimed any interior damages and they never went into the interior, would that be unreasonable? Is that what you're looking for?
it's hard to say. I mean, it depends on, I'm going to give you the BS lawyer answer, because it really depends on the facts of that situation. It depends on if there is roof damage, if there's a leak. I'm not, based on a blanket example.
There's a hole in the roof, and
Sure.
it's really obvious when you're on the roof and the adjuster's on the roof and he can see into the attic. He probably would know that there's an interior leak.
Absolutely.
Even if it doesn't show up on the interior because the insured has oil-based paint on their ceiling and the stain hasn't come through, the adjuster probably knows that the insulation is wet and the drywall is wet, even though it's really not showing up.
Right.
So he should go into the attic at least.
I believe so. I believe that would be conducting a reasonable inspection, an investigation on.
What if it is unknowable? If there isn't anything obvious, wind damage, shingles are missing, but the insured says there's no interior leak, and the felt is still intact, and it's unknowable. Do you think that the carrier should go inside and take a look around?
Well, if you're asking my personal opinion, I think they should, and it depends on.
Would it be considered unreasonable if they didn't in that kind of situation?
It's arguable. I believe that. I mean,
so they could have acted in bad faith unknowingly in that case, possibly.
They can, but in a situation
wouldn't
like
have
that,
been
you wouldn't get
intentional.
exactly, and that's whenever you wouldn't necessarily meet the threshold for treble damages.
Okay.
Where, hey, there's a bad faith case, right? We have a good bad faith case, it's home run, but the insurance company didn't knowingly and intentionally act in that bad faith. You're not going to get treble damages. And I think that that's a common misconception. People think just kind of link bad faith with treble damages. No, the insurance company has to act knowingly and intentionally, and then, and only then, you pursue trial. And then if the jury and judge finds it out to be, then you can have a case for treble damages.
Interesting.
Yeah.
So, what is unreasonable generally? Is this something where it's their would best practice, if they followed their own guidelines or best practices,
Yeah.
and let's say the best practices themselves are unreasonable, but this is something that they do for every single claim the same way. Do you think that that could ever be construed as an act of bad faith?
If they continuously and systematically,
But it's written into their best practices or company guidelines, OG, whatever it might be, depending on the carrier.
right?
If they're following those guidelines that are written, and you find the guidelines during discovery,
Sure.
and you find out that it isn't in their guidelines that they need to go into the interior if the insured says there's no leaks, for example. Could that still be an act of bad faith?
I think that a lot of courtrooms and judges and juries could find that it is. I don't necessarily think that the common guidelines that the insurance company follows trumps statutes and trumps law in general, though.
No.
But what I found is common examples of bad faith or something that would be unreasonable, right? You have a delay or denial with a non-justifiable reason. You
No
have
basis for it.
exactly.
No realistic basis.
Exactly. You have improper investigation, and that's one of the specific examples that I want to touch on a little bit further. I have 3 different cases to kind of give you some funny examples as to what constituted bad faith in that instance. Failing to inform the insured of the appeals process. This is stuff we've all heard before in the industry. Failure to provide a reasonable explanation for denial or underpayment. A lot of times that's what we tell these insurance companies is, please provide a reasonable explanation as to why you denied payment, or, pay out the claim that you're supposed to pay. And if they don't adequately do that, then that's barking up the tree of bad faith, in my opinion.
Do you say please?
It depends on how friendly they are. I like to maintain as composed a personality as I possibly can. I like to be nice. I think if it's the ultimate leverage, being nice. I think if someone's an asshole to me and I still am nice to them, that is the most amount of leverage that I'll be able to get in that situation.
I don't know. Do you think you gain leverage? You definitely piss that guy off.
Sure.
Whether
And
you gain leverage or not, I mean, it's not really a contest on who can be nicer. The nicer
No.
person gets the most leverage. That would be an interesting life.
It would be a very interesting life.
The world would be a better place.
But the leverage in terms of, I mean, we're getting deeper now into it, but like how you feel on the inside, right?
Yeah.
Being nice, in my experience, has given me a lot of leverage in a professional career, in a school environment, in creating
Works with
content
my
in
wife.
general. Works with your wife. Exactly. So, but a couple cases that I wanted to point out, and let's talk about the bad faith example of denying a covered claim without conducting a reasonable investigation. Okay. So these are all Texas cases. Put me on short notice, a little bit longer. Might have gotten some Georgia ones, but there's one, Renninger versus Allstate. Now, in this particular case, the Allstate didn't do an interior inspection, and it would have been reasonable to do so. Now, the policyholder asked for a reinspection, and what Allstate said is they told the insured, quote, "We'll reinspect, but the second guy isn't going to find anything new." Okay? They didn't send out a second engineer. They didn't send out an engineer at all.
Is that okay? That brings up a good question.
Okay.
Does an insurance company have to send out a causation expert in order to have fully investigated the loss?
That's a good question. And I think it goes on a case-by-case basis. I don't necessarily think it's 100% necessary. I think it is reasonable, right?
It would be reasonable, especially if there is a disagreement.
Absolutely. So that was one of the cases where they didn't properly conduct a reasonable investigation, and that was barking up the tree of bad faith, and actually was found to be so. A second case that I found that was really interesting is this was USAA versus Griffith. Now, this is a case where AllCat only inspected the lower slopes of the roof. Okay, the engineer didn't even set foot on the roof. Right?
Engineer didn't. There was an engineer.
There was an engineer in this one. They did not step foot on the roof.
Okay.
Okay. And AllCat only inspected the lower part of the slope. And they used, tell me if you've heard of this, because I haven't. They used a 6 by 10 foot test square. Have you ever heard of 6 by 10 foot?
You can use any size test square you want. It just
traditionally
makes the math
what do you hear?
It's either 10 by 10, 5 by 5, 10 by 5.
It's just
usually
weird.
it's multiples of 5 because it's easier.
Right.
I've done some triangles before just because of the shape of roof.
Okay.
Sometimes you have to get creative.
Okay.
You ever had one of those dome roofs?
Yeah, a lot of churches.
So
churches have
I'm not mad about that. It's still
just a
doing
little
an
hairy.
investigation.
I'm not
It's
saying
weird.
that the 6 by 10 test foot square that's bad faith. No, it's just weird.
Yeah, it is
adds
weird.
adds to the story. We're like, what are they doing?
Does he even know what he's doing?
Does he even have the requisite capabilities to conduct an adequate search?
Maybe he was going to do a 5 by 10, but found some additional hail 1 foot lower than the square.
Perhaps. You're
and was
very
trying
kind to
help
assume
the
that, but
insured.
perhaps.
He was a very nice guy. I mean, he worked with AllCat.
And my favorite one about this, now tell me if you'll give him the benefit of the doubt on this one. The engineer stated, quote, that baseball-sized hole in Griffith's pockmarked satellite dish was caused by a baseball rather than hail. So
He found evidence that it was a baseball, I guess. Was
They were
there
playing
a
a minor
baseball
league game.
field nearby? That's a hell of a hit.
I know, right?
Right.
Yeah. You think, yeah. So that was one where it's like, what's
Was
going on
caused
here?
by a baseball.
Exactly. And then the last one that I had was what I described earlier. This is State Farm versus Vega.
How do you have the quotes?
Looked up the cases.
Was it hearsay in the case?
Well, I don't think so. Not if it was in the.
So was there a recording, you think?
Well, there's a bunch of different hearsay rules, and I'm not sure which it fell under, how they got it in, but it came into trial.
Huh.
So the last one that I already touched on a little bit is one that's another interesting one. It's just the fact that they did not come in and inspect the attic whenever they should have reasonably done so.
Okay.
So those are all situations where you're dealing with something that turned into bad faith.
Let me tell you something.
Sure.
Most of what you just said has happened to me on almost every claim in Georgia.
Yeah.
Very low percentage don't have a situation like this on any claim in Georgia. And you other Georgia PAs that are out there that have the similar experience or contractors, please mention something in the comments. I can't be the only one. Maybe they're just screwing me. I don't know.
Maybe they have something against you.
There's
What's a good example or a story that you have that stood out to you out of all your claims? I'm sure you could be here all day telling me about them, but is there one that sticks out more so than the others?
yes.
What did that look like?
I've had one on a condominium.
Okay.
Well, actually, a homeowner association, not a condominium. So multiple buildings with multiple units in each. But I guess that's a condominium.
Mm-hmm.
I don't know.
We'll call it a condo. Who knows?
It had an HOA. And they asphalt shingle roofs, and there was wind damage all over it. 4,957 wind damage shingles on the entire complex. And the insurance company said that it was repairable.
Okay.
And the roofs were old, quite old. The condition was rough. When you step in places, granules can fall off. There was missing shingles. There were torn and creased shingles. The insurance company sent out an engineer, and this has only ever happened with this particular insurance company, but I've seen it happen on multiple claims when this particular insurance company was involved.
Okay.
The engineer wrote that because previous repairs exist on the roof, that is proof that repairs can be made and are possible. Well, technically, yeah, that's proof that repairs can be made. It doesn't mean that repairs can be made properly.
Exactly.
And those previous repairs that he pointed out, he took photos of and posted on his report 2 previous repair areas. There's probably 50-something previous repairs on these roofs because they're old.
Right.
And every single one of them looks like trash, except for these 2.
Okay.
So that report ended up with those really good repairs to prove that those roofs are repairable.
Right.
We sent out an engineer of our own, and he said it's not repairable. And they said, well, we disagree. We said, well, we'll be happy to meet you out on site. Let's discuss this on site.
Absolutely.
And they said no. And about 4 months goes by of a back and forth where we're just trying to get them to reasonably meet us on site. They said no. We sent in our own attempted repair videos with 2 different contractors. We disagree. We got a second engineer involved, who then also said it's not repairable. And they said, well, we disagree. Our engineer says it's repairable. Our engineer then writes, and their engineer wrote a second report, a supplemental report. They said, you could use this roof snake tool. I wrote a white paper on this yesterday, by the way, this tool. So, and there's videos I already have out. So I'm not really going to describe the tool, but it's a bullshit tool. All right. It's just bullshit.
Yep.
Anyway, engineer actually puts that in his supplemental report and stamps it, which was really interesting. Well, we've got 2 engineers that say it's not repairable and 1 engineer that says it is. Their engineer.
Sure.
And of course, they're going to stick to their expert's opinion.
Always.
Because that gives them their reasonable basis for the denial.
Yes.
If they hadn't expertised and found someone to put in writing that it was repairable, then they wouldn't have that basis for denial that would have made it an unreasonable denial. But we had 2 experts that said that it wasn't repairable, and contractors that said that it wasn't. We ended up having to go to the Department of Insurance. It's one of the few times that filing a complaint with the Department of Insurance actually had fruit. The department recommended that we all be on site, as we had been asking them to do many, many times. And we allowed the carrier to bring out any contractor of their choice, any contractor, whoever you want, bring them out on site. Let's have them attempt to repair in front of us. We showed up, me and I had 2 other guys, one guy that was going to hold a camera and another guy that was going to be there on the roof with me watching it. They had 15 guys show up. 4 of them were the roofers.
Okay.
The attorney that I had been fighting with, who came from New York to Georgia for this, and 2 engineers from that engineering firm, the adjuster from the TPA firm, and the adjuster from the insurance carrier. All of them are all there. I might have miscounted. It might not have been 15.
Somewhere around there.
It's a number, and it's high. And we recorded the whole thing, and they had that contractor use that stupid roof snake tool.
Yeah.
And very soon I'll be able to post that video because it's ridiculous. But he spent 25 minutes just breaking the seals on the shingles, and they were tearing up like crazy, constantly. Couldn't do it. He couldn't do it, and he's sweating because it's hot. It's horrible conditions.
Yeah.
We had him do this on one of the newer roofs because usually when there's a HOA or condo association, there's sets of buildings that are built at the same time. They have different what's the word? Phases, different phases that are built. And we got on the newer phase to make sure that it was the most reasonable way. This is our control. If you can't repair this one, you definitely can't repair the older ones. At the end of the 25 minutes that he tore the crap out of the shingles, just breaking the seals, I said, do you think this roof is repairable? He said, no. I was like, well, there's 4,947 of these. You just did one. You have 4,946 to go, but don't worry.
Have fun.
Exactimate gives you $19 per shingle.
Right.
So it's plenty of money. But now we have to replace all the ones that you just damaged as well. When he used the roof snake tool, he ended up having impact damage, and he drove several nails crooked as well. That's a whole nother story. I'm not even going to get into that.
Yeah.
I thought we were golden. The insurance carrier brought out their engineer and their roofer, their choice roofer. That engineer wrote a 3rd supplemental report, or a 2nd supplemental report, the 3rd report.
Sure.
And said, we still think the roof is repairable.
No kidding.
Yeah. And he said that the roof was just too hot. That's why we couldn't break the seals cleanly. So you should pour water, cold water on the roof that has missing shingles before attempting to break the seals.
It's ridiculous.
It is.
It's an understatement.
It is.
Too.
Oh, man. I was really hands-on on that one. It ended up in an attorney's hands.
Sure.
And everything has worked out.
Good.
But, man, that's a bad faith case.
100%.
Yeah.
Yeah.
You know what would have happened had we didn't go to trial, and we didn't actually end up going to court at all.
Settled.
The attorney was able to talk them into. Actually, they sent us an appraisal demand at some point when they realized that things were just completely out of hand. But their appraisal memo was way off compared to the actual appraisal language in the policy, and it gave them a lot of power that they didn't need to have. So we got the attorney involved in order to negotiate the appraisal memo, and then an appraisal happened, and it ended up getting paid probably 4 months later than it was supposed to have been paid after the award was actually submitted. But there's a lot of delay, a lot of bad faith.
Absolutely.
To be honest,
Yeah.
half of the crap that I just told you in that story happens on the majority of the claims in the majority. Because no one's getting their hands slapped out there. It's a state that has almost no leverage.
Case law? What's the case law like out there? Do you know?
Very limited case law.
Yeah.
Very, very limited. But we don't have any dispute resolution available to us. The appraisal provision is broken. In Georgia, amount of loss doesn't include scope differences. So if you have one line item difference, you can't go to appraisal. It's a big problem.
Yeah.
And we don't have any time frames that they have to abide by.
Yeah.
The
This is one of the tougher
statutes,
states then.
it's
Absolutely.
terrible.
Yeah.
So a lot of this happens in states that have less leverage.
Sure.
The attorney's fees aren't going to get paid.
Right.
You can expect that. So going to an attorney right away when there's a problem isn't normally in the insured's best interest if it's a small claim.
Right.
The attorney's going to take 30%.
Right.
By the time they actually get paid the funds, they don't have enough money to actually make the repairs. It might not be in the insured's best interest. It's in the insured's best interest to let the public adjuster keep fighting it. Spend a lot more man hours on that claim. We end up coming across, and almost everybody that works in states like that, they have these kind of issues all the time.
For sure. And that's when you have to turn to lobbyists, right? I mean, you either make good case law, get attorneys that are willing to take those cases on, take them to court, and stick it to the insurance company so good case law develops from that point on, or the only recourse is getting with your lobbyists. I mean, lobbying becomes a full-time job. If you're trying to actively change the case, just the law, not even the case law, but the law in a state for first-party insurance work, it becomes a full-time job that you're doing that. So that's kind of what you have to do is you have to get together as contractors, as PAs, as attorneys. Everybody has to come together and try to make that change like that. And that's one vertical that you can try to make change in your state. The other is, like I said, having an attorney take the case and making good case law out of it, which is, it's tough whenever you have a state like Georgia where it's pretty damn strict compared to a lot of other states out there like Texas, like Colorado. Colorado is one of the friendliest, probably the best state for the policyholder to be in based on the law. So it's just tough, really tough whenever you have a state like Georgia that you're dealing with stuff like that.
It is.
And hearing your story real quick, I wanted to add one more thing.
Okay.
Is it reminded me of just some of the weird stuff that comes in this industry. For example, there was a case out of Texas where a judge ruled that the insurance company sent somebody out to inspect the property 3 different times. And they found that just because they sent them out 3 times, that was a reasonable investigation.
It's the same guy every time?
No, I think they were different guys. But I'm not 100% sure on that.
Do you think that a proper investigation happens? Does a second inspection even count if it's the same adjuster?
I mean, I would argue no.
I would argue no.
The
carriers don't want to say that that's true.
But say,
clearly.
let's take the example. Let's give the insurance company the benefit of the doubt. Say on these 3 inspections, they sent out 3 different individuals. But that logic doesn't make any sense to me, saying that 3 investigations is reasonable. What if they would do 3 investigations at the neighbor's house? Right? And that was the 3 investigations that it was sent out. What if they did it inadequately, improperly, unreasonably? It doesn't make sense in my mind that 3 separate investigations or inspections.
Who gets to determine if the investigation was reasonable?
The courts.
Okay, well. The carriers want to say that it's reasonable every time. That
Of course they do.
Provided a full investigation. If they went out 3 times, a desk. I'm going to defend the insurance companies.
Go for it.
What is wrong with me?
What, did someone slip some into your drink or something? What's going on?
Oh my God. I have to argue everything.
That's all right. Go for it. Beauty of debate.
If a desk adjuster who doesn't go out on site, is told by their field staff that a full investigation has happened, and they see all the photos, and they don't know what's missing in that photo set. They don't know as long as they know that their adjuster met their guidelines or can explain to them the story in a reasonable manner. They're assuming, I would expect, they're assuming that a proper investigation has been made, and that the rest of this is just fraudulent behavior by the insured or public adjuster or contractor or something along those lines.
Well, I mean,
I bet they think that we're all complete crooks all the time.
Well, it's interesting. I mean, I've never worked on the insurance side of things, and a lot of people in this industry have the benefit of having that experience before they come on to one side or the other, that they have both sides of the spectrum to really understand how things work from both different agendas.
I think the biggest obstacle in a lot of this comes down to the word reasonable.
Absolutely.
Whether something is or isn't reasonable to a layman,
Sure.
because it's a jury that's making this determination. Is that true for most or all states? Do you know? Does the
jury comes down, well, there are
does
different.
a judge ever make the determination on whether or not bad faith has occurred?
There are two different types. Yet the jury can decide or the judge can decide.
Okay. All right.
That being said, though, you're right.
I bet reasonable is different for a judge versus a jury.
And it depends on what type of case it is. But, you're right. So the jury is filled with a bunch of lay people, right? And it depends on whose story sounds better, right? So you have evidence that the baseball-sized hail was caused from a baseball instead of an actual storm-related damage, and it just sounds like a ludicrous story. So a lot of it, it boils down. Go ahead.
Do you think if someone like, I don't know, Jason Bay or someone like that created a video to play in front of the jury to really tell the story, that would probably do well?
Well, we're getting into trial tactics, and that's the whole thing, right? Like, let's take a slight detour talking about, like, I hate to go here, but like the OJ trial, right? Whose story was better? I don't know what happened. I mean, I don't think anybody really 100% truly knows what happened, but we know whose story was better.
There was some celebrity involved, so that always changes people.
Of course, but the circumstances that were surrounding that trial, along with
that glove slightly didn't fit.
And it all added to the fact that there was a better story told. Now, I'm not saying that a court case or an argument depends on who can tell the best deceitful story or anything by that means. It's just the better information you have, the more information you have, the more detail you have, the better your case is set up, the better your file is set up. It gives you that ammunition to really build a story, right? We're not trying to say, oh, let's come up with the best story, and the insurance company saying, yeah, this is going to be bullshit too, but my story is going to be better than yours. Like, it's not like that. But essentially, stepping out, that's essentially what it is being able to tell a good story of what happened. That's why it's so important to document.
I said Jason Bay earlier. I meant Michael Bay.
I know what you meant.
I don't know where Jason Bay came from. Maybe I was thinking of Jason Bourne.
Jason,
is that a Michael Bay movie?
I
hope it is.
Is it?
It would make me feel better about the gaff.
Jason Bay. I was like Jason Bateman.
Jason
Bateman. I don't know.
I like him.
Jason Bateman's a great guy.
Dry.
Yeah, that's my favorite type of humor as well. Dry humor, dry, awkward, self-deprecating humor. I think that's my favorite.
Yeah,
but it's neither here nor there.
I don't like it.
You don't like dry humor?
No, I think it's shit.
Yeah, that's what I'm talking about. I like that. But that goes back to my point. Stepping back to where we were is the importance of setting up a good, proper file. And if you're going to go the attorney route, if you're going to go the PA route, it's necessary, whether you are the PA going to an attorney or you're a contractor going to a PA, you need to have good files set up so that our job can be easier.
All right. So how do we set up a file that we think has bad faith? Well, let me ask you this.
Sure.
You have an attorney-client privilege as an attorney.
Yes.
It's not your case yet.
I'm pulling up a picture, by the way. I'm not texting. Go ahead.
I don't believe it. I lost my train of thought. Oh, okay. So a public adjuster, I don't know if they have any privity rules, to be honest, for at least for the states that I've worked in. Obviously, you can't share private information from your client to other people, but is it okay for a public adjuster to discuss a case with an attorney without the insured's knowledge?
It depends on the intent and the circumstances. Of course, these are annoying lawyer answers saying it depends, but it truly does.
Every single time.
It truly does depend. But this is bullshit. No, so I think that.
What if I told you the camera wasn't rolling right now? Would you give me a real answer?
That would be my answer. Is that it depends, because it truly does.
Damn.
Law school trains you well. But going back to setting up a file, right?
All right.
How do you set up a proper bad faith case for an attorney or a public adjuster, right? Now, this is not my doing. These are the ABC's 1, 2, 3s of filing a claim. This was done by London Crowns, one of our shareholders at Daly Black. Got to give him the props because he came up with this.
Okay.
I didn't want to miss anything, and this is as good as it gets. So step 1, you have to have a covered peril.
As good as it gets. That was a Michael Bay movie, I think.
Of course it was Michael Bay.
Yeah.
And Jason Bateman was in there as well.
Jason Bateman.
So a covered peril first and foremost, right? So did peril cause the damage, right? When did the peril occur? Is the peril covered under the policy? Those are all necessary questions that you have to answer first and foremost that should be in the file, right? That's the starting point, because that's where the burden shifts.
What if you don't know what the peril is?
Who's you? The policyholder or the...
Let's say the engineer says it's mechanical damage.
Okay.
Which means nothing to anybody. But it's also not excluded in the policy. Is that a covered peril?
Well, it depends. We have to do some further investigation.
It depends.
It depends. It depends. But I mean, who
has to do further investigation? I'm changing gears on you.
Sure, go for it.
This is a big topic.
Okay.
I was about to make a video about this anyway.
Okay.
The hell is mechanical damage? So if a lot of engineers cop out with this term.
Okay.
It's almost like a cop-out term because
Saying
they can just say
damage.
mechanical to mean that it was anything other than the cause of loss that they're trying to not say. If for wind damage, for example, and that's usually when I see it is if I'm on a wind damage claim and there's crease shingles, the adjuster might say, well, I don't think that's wind. I think that's mechanical damage caused during previous aggressive inspection services.
Okay.
Which implies vandalism, but they won't say vandalism. And so the carrier won't apply coverage for vandalism. They'll say, well, the engineer said it's mechanical, so denied, but there's no exclusion for anything with the term mechanical written in the policy. Why are we not fighting for mechanical damage coverage? It's not excluded. If it's an all-peril policy, an open peril policy, then it has to be specifically excluded for there to be a denial,
Correct.
for them to have a basis.
Right.
So if you ever see mechanical damage in an engineer report,
First of all, the red flag goes up immediately.
Right.
Yes.
Right. And then they deny the coverage. Do you think that's bad faith? I just tied it together.
Well, I mean, I know I'll give you your on-camera answer that you're looking for. I think that it's barking up the tree of bad faith, but it's so hard. I mean, you can't just say, yes, of course that's bad faith.
Well, I mean, you obviously, you try as a public adjuster, you
Sure.
try to, please give me clarification. What
Sure.
does the engineer mean by mechanical? Is he applying that it's vandalism? Is he trying to say that the shingle damaged itself or that a machinist got on the roof and machined some new shingles or something with a CNC machine? Mechanical. That is such a weird term.
It's bizarre. And that's the annoying thing about
What's I'm going to look up the definition.
Yeah, let's do it. It goes back to like all these ambiguous words. What is mechanical? What is reasonable? It all comes down and boils down to the argument.
Working or produced by machines or machinery.
Okay. And then we got definition 2. What's that say?
Or of a person or action not having or showing thought or spontaneity, automatic. Noun, the working parts of a machine, especially with allusion to Shakespeare's A Midsummer Night's Dream. I don't have Black's Law available to me, so I can't look up
the Black's Law definition of mechanical.
Yeah. You
Right.
think they'd have a definition of mechanical?
Maybe. I have the Black's Law Dictionary, and it is an extremely thick book that I was gifted to at the beginning of law school that I got extensive use from the first semester, and then after that kind of dwindled away.
Really?
Yeah.
You should open it up and see if mechanical's in there. I'm very curious.
Absolutely. Well,
Yeah?
let's check it out now.
Well, you can do it on your phone.
Absolutely.
You took a picture of every page.
So let's go. I'm going to throw your question back at you.
Okay.
So mechanical, if they say it's mechanical, is that bad faith in your opinion as a public adjuster?
I think that, well, if the engineer says mechanical, I don't think that's necessarily bad faith. I'd be worried about what that engineer actually means. What I find to be the bad faith action often with this situation is I'll ask the adjuster to ask their engineer for clarification, and they'll refuse to get the clarification from their expert. So if they refuse to clarify it, I think that's an act of bad faith.
That's definitely adding to the fact pattern that would be bad faith. For
Absolutely.
Sure.
So I'm
Getting to the
I'm
true
up
intent.
the tree. I'm not just barking at it.
You're not just barking at it, but you're
There's
up it.
a bad faith tree. I'm sitting in it. I got a hammock in that thing.
No, they don't. Okay. What is mechanical according to Black's Law Dictionary? Having relation to or produced or accomplished by the use of mechanism or machinery. Used chiefly in patent law.
So mechanical damage. How could vandalism be mechanical damage? Most of these guys are lifting a shingle by hand and then like pushing it. Is your arm the mechanism?
Could be. You know what I honestly think it is, Matt? I think it's just another tactic from the insurance company where if they have any reason whatsoever, they're preying on a lot of inexperienced people or lazy people in the sense that they're not going to fight that. Oh, the insurance company gave us they said it's mechanical. Shit, might not have anything here.
And the layman sees the denial letter for mechanical damage. It wasn't the peril that they filed under, and they think that that's done.
Well, because they're saying that the
got
insurance exactly because the insurance company has all the leverage. Going back to that, where they have all the expertise, and if they're saying
even
it's
though
mechanical,
they weren't being nice.
Exactly right. And if
Weird.
they say it's mechanical, it probably is. Let's just throw this up and not even worry about it, not do anything further. And that's the name of the game, in my opinion.
I've got a few cases right now with an attorney where we are fighting that we believe that there's coverage for mechanical damage because there isn't an exclusion.
Say that again.
We believe that there's coverage for mechanical damage.
Okay.
Because mechanical was determined to be the peril.
Okay.
They refused to expound upon that or ask their engineer for more clarification. Since they didn't name a peril other than mechanical, well, that's covered because it's not excluded. I have a few cases right now with that. We'll see how that goes.
That's interesting. You have to let me know how that turns out. Now that goes back to our main point of why it's kind of the law change to have a tort cause of action as well as a breach of contract cause of action. Because you look at the insurance company and the disparity of the
I had
expertise.
a Pop-Tart this morning.
Did you?
Yeah.
What flavor?
It was strawberry.
Was it?
Yeah.
It's about as basic as you can go, Matt.
What's a tort?
A tort is a civil...
For my audience.
A tort is a...
Clearly not because I don't know what a tort is. I definitely know what a tort is.
And Shelby Moore, this is a huge shout out to you. Shelby Moore was my torts professor in law school, and she engraved this definition into my brain.
Did she serve tarts?
No. A tort is a civil wrongdoing where the compensation is monetary as opposed to criminal, right? So you have criminal and you have civil. So torts are assault. Now this kind of gets into a hairier situation because
not criminal?
In criminal law, there is also assault and battery. But on a tort level, there's assault and battery, but kind of get those out of your mind. There's trespass, right? Okay. Trespass to land, trespass to chattels, just trespassing out, taking, if this is your mic, I'm taking it.
That's a chattel?
The microphone is the chattel.
That's a chattel.
It's a chattel. These are law school words that don't mean much to anybody else. But where a civil wrongdoing where money is what you get as opposed to jail time.
Right.
So I want to sue you. I'm going to get money from you as opposed to the state taking matter into its own hands and putting you in jail for whatever.
Okay.
So that's kind of what a tort is. Okay.
That makes sense.
Not a tortoise. That's what a tort is. See what I'm saying?
Did she make that joke too?
No, that was actually off the top.
Wow.
I know.
I'm impressed.
That's the reason to go to law school. Helps you think on your feet. Just dish out a couple
You're on your ass right now.
Couple $100,000.
You're sitting.
6'4". Now I'm sitting with my feet on the ground.
Yeah. Attention to detail. Alex.
Oh man.
All right.
But-
So a tort.
Tort.
Back on top.
Okay, so
Okay.
that's essentially what it is an insurance company has exclusive control over the evaluation of a claim, over the processing of a claim, over the denial of a claim. So that's bad faith, right? That will fall under the tort. So let's just talk about bad faith. We have
Okay.
the bad faith, right? We can sue an insurance company for breach of the contract, but you can also sue them for something extra, the bad faith part of it as well. So that's
Okay.
kind of the tort. And that's where California really gets the kudos, where we're like, hell yeah, California, thank you for implementing that in, where now we have a separate tort, bad faith, cause of action, right? Because the insurance company
But
has...
not every state has a private cause of action for that, though.
That's right.
In
And it
fact,
depends. I wish I knew all 50 states off the top of my head who does and who doesn't, but
Well, the main states, the states that have a lot of leverage, the ones that are typically good for consumers,
yes.
Colorado, Texas, Florida.
Yep.
There is a private cause of action in those states.
Mhm.
For a lot of the states that don't have any leverage, Georgia, there is no private cause of action for any of the unfair claim settlement practices. So if it's an unfair claim settlement practice that becomes the tort, then you can't sue directly for that. It can be a secondary that's tacked on with a jury.
And it's, to couple that, let's think about the states that don't have good laws. And it's problematic for attorneys too, because we want to come in and help. But in a situation where you have bad law in the states where attorney's fees aren't necessarily recoverable,
Mhm.
right? It tends to need to be those bigger claims where an attorney can come on board. And that kind of adds to the story where it's like, you won all of our big claims. Thanks, jackass. And it's like, no, well, think about the situation. If we were to take that case to get compensated for our fees, a lot of times we would have to dip into maybe, I don't know, the policyholders' fund that they get from the insurance company. And then they can in no way be made whole. They cannot be truly made whole.
That's true.
So that's a problem for a lot of attorneys too, in a state, getting involved in a claim in a state where they don't have favorable laws that I found.
I never heard it said that way. That's a very simplistic way of explaining why a fee shift needs to happen.
Exactly, and we can get into the
Because
minutia of it. But that's
even if
surface
they win
level.
the case, even if they have a settlement, that the settlement amount would be made whole, but now they have expert fees that they have to pay,
And now they're not made
and
whole.
that is additional damages in reality.
Exactly, and that's a case in Texas where, hey, not only are we allowed to cover 100% of the claim, but we're also allowed to recover our attorney's fees.
Mhm.
And that's a situation where the policyholder doesn't have to pay a cent to us. They're never going to get a payment, a payment reminder from us. They're never going to have to pay a dime to us at all. And that's the beauty of states like Colorado, like Texas, where we can get our attorney's fees on top of it as an added penalty. So in no way, shape, or form is the policyholder dishing out any of their money from the insurance company to us.
Do you need bad faith in all three of those states to get your fees paid, or is that just for treble damages?
Well, that's a good question. So a lot of times with attorneys, they tend to have a good amount of leverage against the insurance company. So a lot of times these end up in a settlement where option one for the insurance company is they're paying 100% of the claim plus our attorney's fees, or option two is now we'll pursue trial. And if we're taking on a case, you better believe that we're going to find some bad faith if we're going to do the vetting process and take it on, in which case treble damages are there too. So option one, pay our attorney's fees plus the claim, or option two, pay 3 times what you're going to pay. So that is where the real leverage comes in, to where the insurance company is going to be like, okay, we'll give you what you want now. Here are your attorney's fees paid for.
Do you ever do it like that? Do you ever hold out your hand? Maybe
Yeah.
have like a blue pill in one and a red pill in the other? Take door number one.
Yeah. Door number one. No, that would, it's a good,
you could have a lot
good
of fun
showing
with it,
of
right?
it. Yeah. So that's it's essentially how we can,
I'd have some fun with it.
right? Would you take the blue or the red pill off top?
Which one was the blue one? Take the blue pill and learn just how deep the rabbit hole goes, or was that the red pill? I don't remember.
I don't know.
I love that movie too.
It's a great movie, isn't it?
I think it was done by Jason
Is Jason Bateman in there?
Jason Bateman
Yeah,
was not an actor in that
Oh.
movie.
Should have been.
Uh,
That's Bradley Cooper. Wasn't it? Isn't that Limitless?
Reeves.
Isn't that what you're talking about?
what?
Are you talking? What movie are you talking about?
The Matrix.
Are you talking about The
serious?
Matrix?
The pills.
I know the pills, but there's also the pill of what's the damn Bradley Cooper movie?
Limitless.
Limitless. It gives you the pill. Okay, yeah, the red and blue pill, the Matrix. That's its own thing. I know
It
I'm
was
wrong.
clear and tiny.
All right, I'm wrong. I'll accept it. I'll admit when I'm wrong. I'm wrong.
I'm never going to have you on here to talk about pills. That's the
I'd
wrong
hope
topic
not.
for you.
I'd hope not.
I
But
need
if
to
you
write
ever
that down.
if you ever need someone to give you,
I need Olivia. Olivia, can you please write down never to talk about pills with Alex Hefner?
if you want to talk about doing some Matrix performance and getting a good game of limbo going, I'm your guy.
Are you a limbo
Ooh.
guy?
No, God, no.
You're tall as
I'm
hell.
6'4". I
How
can't
would you
touch
do
my
that?
toes. I cannot touch my toes.
I'm pretty sure you'd end up in a hospital if you tried to do limbo.
I've tried it before. I'm not very good, but
Are you drunk?
no.
You're actually better at it if you're drunk.
Are you?
You get looser.
Okay.
Your muscles aren't as tight.
Relaxed. Okay.
Yeah.
That's a pro tip from Matt.
Right.
Get drunk
And then
before
if
you
you
limbo.
fall and like crack your head on the ground,
Doesn't hurt.
doesn't hurt. Don't even feel it.
The,
Don't
the
even
next
feel
morning it may hurt, but whenever you do it, it doesn't.
it. Yeah. Oh, it might hurt the next day.
Eh.
But if you get drunk enough, it's going to hurt the next day anyway. So who cares?
This is a cool podcast. This is why I wanted to do it. Talking a little about insurance, talking a little about getting drunk and limboing.
Yeah.
The topics are endless here, man.
Yep.
I like it.
You know what we haven't talked about?
What's that?
How to set up a bad faith file.
Ah,
for return.
yes. Let me get back to the
We
picture
don't
of
have
that.
time though.
Ah, we'll have to cover it in the next
Oh
one.
my gosh. I guess we're going to have to do it again.
Yep.
Hmm.
That will be a good one, though.
It will be good.
Hopefully, we can get together in person again. This was fun.
Yeah. I'll be in Texas soon. Where are you guys at in Texas?
Houston. That's
Yeah.
where our main office is. Yeah.
Yeah. I'll be in Houston.
Awesome. Yeah. Come on by,
Um,
man.
Probably the next few months. We'll set it up for then.
Definitely contact me, man. We got a studio at the office, and we can hang out in there and talk
Yeah.
some more about drunk limbo.
Drunk limbo. If you had a limbo bar set up in your office,
I will do
during
it.
the podcast,
Don't tempt me, man. I'll do
Yeah.
it. We'll get it going.
I'm gonna die. Red pill. My wife responded. The red pill is a rabbit hole.
Okay.
Blue pill says I want to. I thought that's what it was. What beard steroids does Matt take? First of all,
tell me.
Elijah, there's only one T. Just one.
One T in Matt.
Yes. And the steroids are just, manliness in a pill form, right? So I wake up every morning full of manliness and I squeeze and it comes out my face.
That's awesome.
Yeah.
Now, so one quick topic that we're gonna have to cover next one is Matt with one T versus two, because I think that there's some interesting things about you and some birth certificates that I may or may not have heard about discrepancies about the spelling of Matt.
Look, my parents screwed up some paperwork when I was young, which is why it's odd.
Is that right?
Yeah. Yeah, my
They
parents
put it
were
as
great
one and it
people.
was supposed to be two T's.
So one of them did birth certificate paperwork and one of them did social security paperwork, and they don't match.
Did your dad come up with one T or was your dad two
Actually,
T's?
I don't remember.
Okay.
I want to say it was my dad that made the one T,
Okay.
but I don't know if that's true.
Okay. I got you.
I
Matt with
want to
one
say
T.
that because I had an argument with my wife recently where I did say that, and I want that to be true, just so that I wasn't lying to her.
So you can win the
And
argument.
plus, I want to win an argument because
Who
you
doesn't?
never win an argument with her. It's
Who
impossible.
doesn't? I mean, you can never
It's
win
terrible.
an argument with your wife. I'm about to get married. My fiance, I don't win
I
arguments
think
either.
that's why guys get married, so they can stop winning arguments.
Yeah, I mean that makes
They
sense.
go through their whole life winning arguments left and right.
and they're like, I don't need it anymore.
This is boring.
It's
I
time
need
to
to
settle
not
down.
win any more arguments for the rest of my life.
Settle down. I like that. Yeah,
I need to get married.
that's the sole reason I'm getting married. That's it.
Yeah?
Yeah.
That should be in your vows.
It is.
I vowed never to win another argument. That's actually a great line. You should totally use that.
I'm going to. I'll give you props
I
too.
wish I had written that in mind now.
I vowed to not win another argument. I like that. That's kind of funny.
Yeah.
In all honesty, thank you so much for having me on, Matt. I appreciate
Yeah, it was a lot
man.
of fun.
Yeah, it
It was
was.
a lot of fun. We could shake hands and act like we're walking away from each other.
Okay.
'Cause I think that's how you end these kind of things.
Okay, cool. Yeah, I'm just going to go ahead and.
Thanks
yeah.
for.
Yeah,
Yep,
it's
all
been,
right.
it's
See
been
you
real. Yeah.
Olivia, hit the button.